Okay, we'll start. Hello everyone, and welcome to today's webinar on protecting you and your client with Ian Quayle. I'm Sally Redman. I'm a customer success consultant and environment consultant with Landmark Information, who are proudly sponsoring today's session. As Ian says in his promotion of this webinar, this guidance is unmissable in making sure each residential property transaction is treated with due diligence and care, particularly when there are so many parts to a transaction to think about, and when times are hectic, things can unfortunately be missed. As an environmental consultant myself, working for Landmark and writing environmental searches for land and property transactions, I am fully aware the reasoning behind risk and due diligence, but I'm particularly looking forward to understanding for myself how searches fit within the long list of things that you need to consider during a transaction. Before I hand over to Ian, who will take you through each of the topics, just a few housekeeping rules. If you have any questions, please can you add them to the chat box, or there will be an opportunity at the end of the session for Ian to answer any questions that you may have. There will be a 5-minute break around 1 p.m. and also this webinar will be recorded and will be sent over to all members after the session ends. Just a quick introduction to Ian. Ian is IQ Legal Training's Chief Executive and is highly experienced in legal skills tutor. He qualified as a solicitor and worked in private practice for 12 years, specialising in property law matters, including residential development work, commercial acquisitions and disposals. Ian has delivered over 1,500 property-related training courses for city and regional firms, local law societies and local authorities. So without further ado, I'll hand you over to Ian, and I hope you enjoy the session.
Thank you very much. It's really nice of you to give me that glowing introduction. And a massive thank you for Landmark for sponsoring Surrey Law Society, and indeed for Surrey Law Society to ask me along. I was laughing there when talking about my experience, etc. Somebody once said to me, well, if you've delivered 1,500 webinars, you should start to get things right for every now and again with that amount of experience. And only yesterday I was doing a presentation for a local law society, and someone asked me how many good legal trainers I'd come across, and then came up with a typical sort of Yorkshire remark, well, there's one less than you think there is, which again I thought was really funny too. So perhaps that puts me in my place. Anyway, seriously, thank you very much indeed for listening today. What we're going to do is be looking at a lot of issues with regard to how we protect ourselves and our firm. And I've entitled it Key Issues for Residential Conveyancers. There's lots of things that we're going to be exploring and talking about. There are extensive notes that accompany this presentation, and hopefully they will be shared with you. We are recording today, so if you're interested in anything that I've said, or you miss a bit, or you have to take a call, etc., then the recording will be available to you for anything that you'd like to go over. If you have any questions or queries, as was said, more than happy to take questions via the chat facility that is available to us, and I will loiter if Helen will let me at the end of the presentation in order to deal with any questions, and I'll also provide you with an email address. So if you're too shy to raise any questions as we progress during the course of this presentation, which lasts 2 hours, you're more than welcome to drop me a note by email. We will have a 5-minute break at 1 o'clock, a sort of screen break, so that you can recharge your glasses of water or attend to whatever needs attending. Great. So sitting comfortably, I hope, can hear me, I hope, more importantly, can see the slides. From time to time, I'll have a connectivity issue. If I do, what I'll do is turn my screen off, but hopefully you'll still be able to hear me, and certainly you should still be able to see the slides. First thing I want to do, and I do this in most of my presentations, is refer you to relevant, useful websites. All these sites, bar one, are free to access, and all are very useful indeed. The PLA website is a site I recommend to all practitioners when looking at best practice or looking at how to deal with problems and issues. Problems and issues ranging from property fraud and fraud avoidance to issues or problems with boundaries, co-ownership, easements, covenants, and the whole sort of shebang, as it were, of issues that transactional property lawyers can encounter. Just about every barrister and QC in the country produces papers and opinions that can appear on Chambers websites, in the Estates Gazette, etc., but ultimately find their way on the PLA website. So if anyone today fired a question at me that I didn't know the answer to, which is something that happens quite frequently, I'll go on the PLA website, have a look and see if there's a paper or opinion written on the issue that will be a starting point for me to give advice or assistance. There's also a case law update section there. Again, it's free to access, so it's useful. So I don't ask for any sort of forgiveness in saying, yeah, it's a litigation website, but it's particularly useful, I think, for transactional property lawyers. The second website, again, is aimed at commercial property lawyers, but there's a boundary dispute protocol that's very interesting and very useful. Over the last few storms that we've had, it's been amazing on LinkedIn to look at the number of people have been sort of giving advice about disputes concerning fences falling down, hedges being damaged, etc. Boundary identification is a nightmare. Legal boundary identification is a real nightmare, and property protocols has a boundary dispute protocol that isn't just a protocol for dealing with disputes, but highlights what sort of evidence is suitable and appropriate when dealing with boundary problems. So legal boundary identification, determined boundary applications, formal boundary agreements, etc. Don't know if you noticed, just recently there was a High Court case that scared the living daylights out of me, where a High Court judge said if parties enter into a formal boundary agreement, it's binding on the parties entered into the agreement, but not binding on subsequent owners. I'm hopeful that that case is either going to be appealed or some court very swiftly is going to say that can't possibly be right. Determined boundary applications are the better choice, but determined boundary applications require the consent of the landowner, the adjoining landowner, the neighbour, and also require a professionally prepared land registry compliant plan. The RICS website is useful. I hope that you've all seen the RICS Consumer Guide to Surveys and Valuations. Of course, in order to protect ourselves and to protect our clients, we should always be advising our clients of the need for a survey. We should be highlighting to the clients the benefits of obtaining the best form of survey they can afford. And the idea of the RICS Consumer Guide is it highlights the different types of survey and valuation, and of course the benefits of a level 3 survey. So rather than explaining to the client in our engagement letter or in our report on title about choice that's available, give the client the link or provide the client with a consumer guide, and everything is there for the client to understand and appreciate. For dealing with leasehold transactions, the Leasehold Advisory Service website is a must, on the basis that there's a wealth of information there that we can support our clients with, explaining the bigger picture concerning leasehold ownership. One of the things that the SRA dealt with back in 2017, and what the SRA and Law Society continue to bleat about, is the fact that conveyancers are focusing in on the detail with regard to a particular lease and focusing in on the particular transaction which our client is involved with, which of course is necessary, but they're failing to advise clients about the bigger picture, the disadvantage of leasehold ownership, the dangers associated with ground rent and service charge, etc. And therefore to have information such as the Leasehold Advisory Service leaflet, Do You Know Your Lease, and the ARMA leaflet, which carries similar information but is a slightly shorter document, we're providing our client with that useful background, with the sort of bigger picture with regard to leasehold ownership. I mentioned the Leasehold Knowledge Partnership. This is a site that is a bit political, to be honest with you, but it's very driven to support leaseholders. And again, if you've got leaseholders that are having problems or issues with high-rise flats and fire safety issues or issues with difficult landlords, then I'd commend the Leasehold Knowledge Partnership to you, because it highlights steps and measures that can be taken when dealing with difficult landlords. ARMA, as I mentioned already, the Association of Residential Managing Agents, has a leaflet about owning leasehold property. Interestingly, it also has a leaflet about estate rent charges. At the moment, I'm getting lots and lots of questions about estate rent charges, and estate rent charges are, one, becoming more commonplace, because as developers are not selling leasehold houses, but instead selling freehold houses and retaining common parts or dealing with issues such as shared facilities, private roads, etc., then they're using estate rent charges in order to recover costs that they're incurring. Just conscious of the fact there might have been someone raising something in the chat, and I haven't, that's okay. Good. If you do, feel free. The chat facility is there for any questions that you may have. Finally, I mentioned Property Law UK. This is a subscription service that produces a monthly newsletter highlighting issues associated with changes in the law and new cases, etc., best practice with regard to conveyancing. Vested interest, I bought Property Law UK from a barrister called Gary Webber in November, but despite my participation in it, we've got about 20 barristers and legal trainers that write articles, etc., that are of interest to practitioners. But unfortunately, you have to pay for that. The other sites are all free, and I thoroughly recommend them to you. If you're interested in sort of keeping abreast of the law and are willing to subscribe, then Property Law UK has some benefits. Good, enough of that. Let's get down to some of the key issues that I refer to in the notes. And the first thing I want to talk today to you about is onboarding clients. And to be honest with you, I'm worried about what's happening in connection with the legal profession and how we onboard our clients, in particular identity verification issues. And the reason for that is that we've now got some superb products, and they are superb products, that enable us to verify client ID electronically. And that's brilliant, absolutely brilliant. It takes out a lot of the risk associated with old-fashioned onboarding, but it also, I think, creates a problem in that our fee earners and indeed ourselves can think that once we've done that, that's us sorted, and that we don't then have to be concerned about suspicions or activity during the life of the transaction. How we onboard a client is critical. Verifying client identity is critical, no matter what procedure or process we use. But being aware of property fraud throughout the transaction, in my view, is critical. I'm not going to bore you with Dreamvar and Mishkonda Rare. It's been done to death. I'm not going to bore you with Singh, which is a case that's not quite as sort of well known, but both of those cases highlight the court's attitude that the idea of client identity verification is not just one task when we onboard a client, it is an ongoing duty and responsibility. So let's just look at how we protect ourselves and how we protect our firm and how ultimately we protect clients in the conveyancing process. No matter what system we're using, electronic verification or manual verification, the old-fashioned paper-based systems, it's important that, of course, that we identify our client. I would always maintain that we should cross-check data and information that's provided by our client. Let me give you an example. If you're acting for me on a sale of registered land, then when you download official copies of the register, would you check the address for service that I've given the land registry and check that there is a connection between that address for service and the contact details or other addresses that you have for me? Remember, an address for service can include an email address. Remember, it can also include addresses out of jurisdiction. So if I've given you my address as 24 Runcorn Street, Guildford, and my address for service at HM Land Registry for the relevant properties 2 Acacia Gardens, Norwich, then at the very least, you should be asking me why the discrepancy. The second thing is that during the life of the transaction, we've performed electronic verification of our client. There may be information that our client produces that's inconsistent with that verification. Again, we need to check. As far as electronic verification is concerned, the land registry is moderately comfortable with it. The profession seems to be getting more and more comfortable with it. All I would say to you, to protect yourself and your firm and your client, make sure that the platform you're using is sufficiently secure, and make sure there's a paper trail with regard to your choice of platform, so that if, God forbid, something happens with regard to a property fraudster managing to sort of circumnavigate the electronic verification process, you can show that you did that which a reasonable conveyancer ought to have done with regard to identifying and choosing the platform that you chose. I mentioned on the slide here that we've got to identify the owners of the legal estate, or the potential owners of the legal estate when we're acting for a buyer. But we've also got to identify beneficial owners in connection with sales. So when dealing with trusts, when dealing with sort of family acquisitions, buy-to-let investments, etc., be careful about that. And this fourth point is, again, something that I bleat on about, and I don't apologize for bleating on about. Identification of client objective is what I call it. The SRA and Law Society call it ascertaining the purpose of the client's business relationship. Why is our client selling this property? Why is our client buying this property, and why has this client chosen us, is really the point that I'm alluding to. From a transactional perspective, from the perspective of protecting ourselves and our clients and our firm, there could be a myriad of reasons why I'm selling a family home. I might be selling it to buy another one. I might be selling it because I'm going through a traumatic divorce. I might be selling it on the basis that I've got financial issues and I need to get some equity or to clear some net proceeds of sale in order to discharge debt. No matter what the reason, you need to know about it. If we turn this on its head and talk about the purchase, why have I acted or instructed you to act for me in connection with the purchase of a property, a flat in Basingstoke? It might be that I intend to live in that flat as a family home with my partner. It might be that I'm buying it as a buy-to-let investment. It might be that my daughter has just found employment in Basingstoke, and being the very kind father that I am, I've decided to purchase a flat for her. Or there could be a whole myriad of other reasons why this particular property is being acquired. You need to know why. Let me explain. If my daughter is moving into this flat and she's going to be sharing the flat with two of her former workmates who are going to sort of share the accommodation, then there is a user covenant that facilitates that use. If I'm going to be using the flat or an apartment as a buy-to-let investment, again, are there any constraints that would preclude me from doing so? If I'm taking an assignment of a lease and my intention is to own the flat for 3 years or 4 years or so, and I tell you about that, it might be significant. There's only 81 years remaining on the term. So this idea about client objective is important. I think it's also important because when we're producing a report on title to our clients, more on this later in my presentation, we can target the report, target our provision of explanation and advice towards that objective. That doesn't prevent us from explaining everything else that due diligence requires, but it does enable us to sort of generate added value for the client. So, hey, Mr. Client, I'm going to tell you everything that my due diligence exercise has revealed, but it's also important to be aware of these particular points in the summary of the report on title that directly impact your objective. Again, it's important that we monitor the relationship with our client. I was speaking to someone yesterday doing a presentation in Yorkshire, and they were telling me about a situation which, unfortunately, I've seen on a number of occasions previous, where husband and wife instruct the firm. Husband says, I'm really busy all the time, better if you deal with my wife in connection with communications, etc., which is exactly what the firm does. At a later date, husband then says, well, hang on a minute, we've acquired this property and I'm not happy about some restrictive covenants that are binding on us that I wasn't aware of. There's no such thing as a collective client. If one client says, don't communicate with me, communicate with my partner or colleague, that's perfectly reasonable, but there are certain things within the transaction, the report on title being the obvious thing, that need to be disclosed to all clients. The other type of situation that again I see, and again it's not that uncommon, is a situation where husband says, my wife is busy working, etc., so don't communicate with her, communicate with me. And then it transpires that the parties' relationship isn't particularly sound and husband is selling the property and wife isn't aware of it, or vice versa. So this point about monitoring relationships is important. Being aware of warning signs, and again, I refer you back to Dreamvar and Mishkondareya and Perensing. The client that's bombarding you to get a transaction exchanged and completed without any real reason as to why there's an urgency. The sale of a property where the property is not subject to mortgage, but of high value, with a client resident abroad. Well, again, just be alive to the fact that nothing in what I've said would be suspicious, but there may be other aspects of the transaction that would lead you to generate suspicion. The important thing is it might not be one thing with regard to your client relationship that immediately triggers an alarm bell with regard to fraud and immediately gets you talking to your compliance team. It can be a cumulative effect, I think, is the point that I'm making. I mentioned knowing your client, and here's another important point. When we talk about protecting firms and protecting clients. There's no such thing as a standard client. Okay, so why do we have standard emails, standard forms of report on title? We've got to be aware of different types of client. We'll touch on this in a lot more detail later, but it's wrong to think that we just have one size fits all with regard to our advice and explanation, etc. And finally, in order to protect ourselves and our clients, it's important, and I touched on this when I talked about leaseholds, that our client understands the transaction, understands the process, understands the significance of certain steps in the process and the duties and obligations that are imposed on the client as a consequence. The obvious things being exchanging contracts, completing duties and obligations to lenders with regard to mortgages. But there are other issues too, of course, making sure that information that's disclosed to HMRC with regard to SDLT is the correct position, being aware of the risk of defrauding HMRC with regard to false apportionments relating to purchase price or splits between fixtures and fittings, thus reducing or eroding SDLT liability. All of those things, in my view, are important. We talked about verification just quickly on slide here. We can still use old-fashioned methods, but if we do, don't just simply take a photograph of my passport, smile when you look at the photograph on the basis that it looks nothing like me, and simply put it on the file and leave it there. You've got to show that you've done something with it. So you've checked addresses, you've checked the likeness if you know me and we've met before, etc., etc. If we've got a new passport, have we seen the old one? If we've got a new driving license, have we seen the old one? If we're not actually going to meet with the client, are we happy with the client simply displaying the passport or driving license in a Zoom or Team meeting and us taking a sort of photograph or a screenshot and putting that on our file? And again, this idea, I think, about cross-checking information is so important. As far as electronic verification is concerned, do have a look at Land Registry Practice Guide 67 if you haven't already seen it. The next thing I want to talk about is the interesting point with regard to the land registry and the property alert scheme. The first thing to say to you is that the land registry has been rather cute over a number of recent years in shifting responsibility associated with seller identity fraud from the land registry to the legal profession. So we've got all sorts of things that potentially impose additional duties and responsibilities on us and remove responsibilities and duties from the land registry. The reason for that, at one stage, over 40% of all indemnity claims that the land registry were paying out were property fraud related. So the land registry has sort of latched onto this quite reasonably and come up with a number of things that I think potentially assist clients in fraud avoidance. The first is the point that I mentioned to you earlier about keeping addresses for service at the land registry up to date and having 3 addresses for service, including an email address. The land registry did originally suggest that clients could use their lawyer's firm or their conveyancer's firm as an address for service, but that didn't find a lot of favour with regard to the legal profession, as you can understand why, and the land registry don't seem to be pushing that at all at the moment. But what they are pushing is the land registry property alert scheme. And again, I think it's important that you explain the scheme to clients and explain the benefits of the scheme. In the notes at page 3, I mentioned that the scheme only applies to properties in England and Wales, and of course those that are registered at the land registry. The client is required to open a property alert account, and the client is required to respond to an email that will be received from the land registry in which the client verifies their own email details. And then what happens is, if the land registry receive any sort of official search or other application relevant to the property that is subject to the alert service, they will alert the owner of the email address that they've activated courtesy of the system. You don't have to own the property to have a property alert relating to it, which is interesting. And when I first looked at it, I thought to myself, that's potentially worrying. Could a fraudster sort of use that service for any reason? Perhaps they could. Difficult to know what fraudsters are up to, but all I can tell you is that the fraudsters that I've seen or dealt with, or files that I've seen, or claims that I've read about, they all seem fairly clever. And a situation where they could potentially receive an alert and then undertake some form of fraudulent activity is not beyond the realms of possibility. Anyway, it's important to understand that properties can be monitored using this system by different people. So again, if a client had a sort of elderly relative that was frail and infirm, and the client was worried about that elderly person being taken in by third parties relating to the property, then perhaps the alert service might be appropriate for them. And the other point to note is that it is important to understand that the service is not dependent on the client being online. The Land Registry can arrange for other systems and processes that would mean that if there was an alert, your client is notified. Problem of all of this, of course, is, and the sort of elephant in the room is, what happens if your client gives the Land Registry an email address and then changes it? In those circumstances, the alert service becomes a nonsense unless the Land Registry is made aware of the change. So I would notify all clients about the alert service. I think it's for the client to set it up, but I think it's your responsibility to tell the client about its benefits. I also think it's important, again, generating client awareness, to tell clients about the risk of fraud. And again, you know, although we see stories in the newspaper, on the TV, latest one in November there with regard to a property in Luton, where sort of fraudsters are sort of acquiring title and then selling it to innocent buyers, I think it's important that we just drum home to clients that this risk exists, is real, and is problematical. Who should the alert service really benefit? Well, elderly clients, clients that are resident abroad, buy-to-let clients, clients whose property is free of mortgage. The next thing I want to talk about is effective due diligence. And again, how we protect our clients as a consequence of the due diligence that we perform. And I think there are a number of points that I want to start with today. Point number one, with regard to due diligence, is that it's not a perfect science. There are gaps and there are holes and omissions in the due diligence process, and there are weaknesses that clients need to be aware of. Again, one of my sort of common themes is to tell practitioners that we are very good at telling clients what we do and how good we are. We're not so good at telling clients about some of the vagaries of the conveyancing process. Let me explain what I mean by that. I think there are a number of weaknesses with regard to due diligence. Weakness number one, I as a conveyancer, you as a conveyancer will not usually inspect target property. And one of the things that potentially can be binding on a buyer is something that would be obvious on an actual or reasonable inspection of the property. I'm thinking here of overriding interests, obviously. So if we are saying, which is what I am saying, that we're not going to inspect, who is going to inspect? Well, our friendly client is going to inspect. But do we drum home the fact that the client will be bound by anything that they do see, or anything that a reasonable inspection would have led them to see? Do we tell them that if they see someone in occupation other than the sellers, that they're put on inquiry and they should ask questions as to who that person is and what interest, if any, they have in the property? So client inspection worries me. The fact that we've got to tell the client about inspection and then make sure the client reports back to us is an issue. As we're going to focus in on now for a few minutes, the issue of searches, I think, is problematical on the basis that searches have their limitations. One, searches may be defective. I was talking to someone yesterday about local land charges and that local authorities' records are poor. And sometimes they are so poor that when a local land charge search is undertaken, the search result is incorrect. Now, yes, it's possible to claim an indemnity from loss against the local authority that produced the local land charges search. Where the process has migrated to the Land Registry, it's possible to claim against the Land Registry. But that doesn't resolve the problem that our client has been hit with as a consequence of a defect in the search, on the basis that if there is a local land charge that isn't revealed by the search, the land charge is an overriding interest that's binding on our client in any event. The next point, again, with local land charges searches, is that they are property specific. And so that if we're interested in an adjoining property or nearby property, then the local land charges search is not going to assist us. I mentioned on the slide here some important points. There are no such thing as usual searches. There are essential searches, which I'm comfortable about: local land charges, search, additional inquiries of local authority. There are essential searches in that a drainage and water search would be appropriate, as would be an environmental search and report. There are then searches that are advisable given location, given nature of client's acquisition, coal mining searches, radon searches, gypsum searches, Rivers Authority, HS2, you know the normal drill. But then there may be other searches that might be appropriate given our client's objective. So someone last week was telling me about their client buying a property. I think it was somewhere in the Surrey region, to be honest with you, and the client was intent on building a swimming pool. And the swimming pool at the deep end was going to have a depth of 3 meters. And there was an issue on the basis that that excavation work would impact on some chalk beneath the surface. And the chalk, I think, belonged to a local lord of the manor or something of that nature. The landowner only acquired the surface to the title, and the mines and minerals were accepted. In those circumstances, the excavation of that swimming pool constitutes trespass. Where you are aware of what your client intends to do, construction of swimming pool, subterranean activity with regard to extending a cellar or underground garages or anything of that nature, could potentially generate the need for a geological search. Again, I'm just going to check, because I think someone was raising a question. Bear with me. No, it wasn't. It must be my eyes deceiving me. Limitations of searches. Again, it's important that clients are aware of the scope of the search. I'm doing a little bit of work at the moment about Con 29, the additional inquiries of local authority and optional additional inquiries, and been doing quite a lot of work in connection with question 4 of Con 29 and the optional inquiries with regard to private roads and private road schemes, in that if you're acting for a client who's buying a property which has a rural aspect or is surrounded by countryside or in an area that is ripe for or undertaking redevelopment, the local land charges search, the additional inquiries in question 4 may not reveal information about road schemes that could impact on your client, whereas the optional additional inquiries would reveal the appropriate information provided the local authority answers the additional inquiries that are raised. So I've seen a few things at the moment where someone bought a property and there's been a park and ride scheme nearby, so nearby that the noise, etc., would impact on the amenity of the property, but not sufficiently proximate to warrant its being disclosed courtesy of local land charges search or additional inquiries of local authority. Remember that with regard to optional additional inquiries, the point is that they are optional and only relevant in certain circumstances. It's for you to choose what those circumstances are. And wherever there's choice, wherever there's sort of potential rather than an actual requirement, that can generate danger. Next thing to talk about with regard to searches is this point I mentioned about essential searches. Local search and additional inquiries, drainage and water search, environmental search and report. And again, to protect yourself and your client and your firm, it isn't enough simply to provide information. So if I'm your client, the fact you send me a local land charges search and additional inquiries with replies and a drainage and water search and an environmental search and report and simply tell me to read these documents is not enough. It is necessary to highlight the entries that are revealed by a local land charges search and information that's generated by additional inquiries. As far as drainage and water searches are concerned, then again, it's important to explain the situation with regard to supply of water and also the removal of sewage, etc., from target property, and how both of those services are undertaken. Of course, where there's a private water supply or a septic tank, then we should be giving advice about ensuring that there are the appropriate easements to facilitate use of water pipes, etc., and what happens with regard to repair and maintenance of water pipes, septic tanks, etc. Which leads me to another point. that one of the things the SRA and a number of professional indemnity insurers have been talking to me about recently is the fact that we've got to have connectivity with regard to due diligence. So if we identify, courtesy of a drainage and water search, that there is a private water supply to the property and that there is a septic tank, then we do need to think about easements. And we do need to highlight to the client the connectivity of the issue that we've identified, courtesy of the drainage and water search, as opposed to the issues that we've identified as to what easements have been granted or which are reserved that either benefit or are detrimental to the property that's being acquired. With regard to environmental searches and reports, again, here I have to just sort of emphasize that what we should be saying to clients is that an environmental search and report is always necessary, but that the content of the report is likely to be so technical that specialist advice is required if any issues are generated. Excuse me for a moment. Note I'm referring to an environmental search and report. The search will include historical land use. The report will include a risk assessment. With regard to contamination, whether your client owns the freehold or leasehold, whether your client is the contaminator or not is irrelevant. The point is, as a landowner or an occupant of land, your client can be liable for decontamination. And the cost of decontamination can be scary in the extreme. We then talk about transaction-specific searches that might be appropriate. So again, the client that's building the swimming pool or excavating the swimming pool, the client that wants to convert the annex into offices, the client that wants to undertake some radical building work with regard to the property and the property is listed or in a conservation area. All of these things might warrant further investigation. And of course, locality is going to throw up its own issues with regard to searches. This last point that I make on slide is an interesting one. As far as your role is concerned, it's important to understand and appreciate that the courts, I think, have been protective of conveyancers over a number of years, in that what they're saying is you are not supposed to be an expert. You are a transactional property lawyer. And therefore, if our search results throw up issues, then what we're required to do is make sure the client is aware of those issues and aware of what can be done to limit or identify risk or vulnerability. Let me give you some examples. Let's assume that our searches reveal that there is an oak tree in the front garden that's subject to a tree preservation order. There are some conveyancers that will tell clients, hey, the property you're buying is subject to a tree preservation order. There's an oak tree in the front garden. Here's a copy of the order. Some firms will say to the client, there's a tree preservation order in connection with the oak tree. You've got to be careful because if you lop or fell it or do any damage to it, then potentially you could find yourself in the magistrate's court and could be fined up to £10,000. Both of those sort of stances would trouble me, because have we explained to client risk or vulnerability, and have we taken any steps or advised any steps that would perhaps assist the client in determining just what that risk or vulnerability could be? What about the third way? Hey, Mr. Client, there's a tree preservation order. We would recommend that you get a report from an arborologist to identify what sort of health the tree is in, what sort of measures might be appropriate to ensure that it stays healthy, and what recommendations are made with regard to the ongoing management of the tree. Now, the client is highly unlikely to instruct an arborologist to undertake the role that we've just suggested. But if he did, then he would be in a better position to assess risk or vulnerability. Let's look at something else. Let's assume that our local land charger search reveals that the property is in a smoke control area. And we know that the property has the benefit of a wood burner in the kitchen. Well, again, what would we do in this situation? We'd advise the client the property is in a smoke control order, advise the client that we're aware that the property has the benefit of a wood burner, and therefore it might be important to determine what sort of fuel is being burnt on the wood burner and whether or not the wood burner is compliant with the requirements of the smoke control order. Or do we suggest to the client, with regard to a wood burner, for example, that it might be appropriate to have the wood burner inspected by a HETAS engineer to check that the wood burner has been correctly connected to the chimney, and that the wood burner and its connection and the chimney don't present any fire risk. Again, I've seen a case where a client bought a property with a wood burner, was in the property 6 months, fire in which luckily no one was injured, but the fire damaged the property so extensively it had to be demolished. Insurance company, with regard to the buyer, had a look at the fire, found the source of the fire was a fault in connection with the connection between the wood burner and the chimney. Also identified that the wood burner had been used to burn wood that hadn't been correctly dried, and therefore there was a high level of soot both in the wood burner and in the chimney itself, and the chimney wasn't lined. Well, in those circumstances, the insurer says, well, we're not paying out. And in those circumstances, our buyer is left high and dry, other than bringing action against his conveyancer in negligence. You should have told me about the need to have the wood burner and the connection and the chimney inspected. I'm a little bit more detailed than that in connection with wood burners. I'd want to know that the chimney had been swept. When was it last swept? I'd also want to know about what sort of wood is being burnt on the wood burner. Has it been appropriately dried? Or frequently where a wood store is bought by a buyer, is the wood just collected by the seller, and therefore it's impossible to gauge how old it is or what level of damp is still in the wood, therefore what level of soot congregation can occur when that wood is burnt. We're not supposed to be experts about wood burners. We're not supposed to be experts about trees. We're not supposed to be experts about planners. We are required to highlight to our clients some risk or vulnerability and to advise our client what can be done in order to reduce or eradicate that risk. I always think with regard to searches, we should say to a client, look, here's a list of the searches that we could do for your property, courtesy of our search provider. What searches would you like us to do in addition to those searches that we deem necessary or essential? Just in case you don't believe me with regard to the limited extent of our duty and obligation in connection with searches, I've thrown a little bit of case law at you in the notes. Orientfield Holdings and Bird, which I'm sure you'll have seen in the past, highlights that solicitors are obliged to undertake investigations that a client expressly or impliedly requests. A client would impliedly request investigation where there's an adverse entry that would impact on either client's objective or valuation of the property or amenity or use. And if they consider that information might be important to the client, they have a duty to bring it to the client's attention. Now, what a lot of firms do is have a scattergun approach. They just tell the client everything. A lot of firms don't have a scattergun approach and tell the client everything. They just say, have a look at that and read it and find out for yourself. I think we've got to provide information combined with an explanation and provide a client advice. There is some potential vulnerability here, Mr. Client. This is what you can do to reduce or identify the extent or the scope of that potential liability or vulnerability. And then AW Group against Taylor Walton, a similar thing. This was a case involving some enforcement action, and the court said solicitors should always give their clients sufficient information about the planning position in order to enable them to seek advice. It's no use to say, I don't know what my client intended to do with the property. It was up to the solicitors to find out, which again gives me justification for the point I made earlier. What's our client's objective? Then to ensure the clients had all the relevant information and understood their legal position. So again, in order to understand your legal position, it's no good just me simply providing you with information. I've got to provide you with an explanation and then explain the advice with regard to risk or vulnerability. Next thing I want to talk about is some local land charges searches, and just to explain a number of things. Firstly, as I've mentioned to you already, the position with regard to a local land charges search is as follows. 1, Land Registry is now having local land charges migrated to them, which means that a local land charges search can be obtained, an official search can be obtained at a cost of £15 from the local land charges department of the Land Registry. However, only 33 local authorities have thus far migrated to HM Land Registry. And if you do a search of HM Land Registry, there is a local land charger search. If it's an official search, you can undertake additional searches free of charge for the next 6 months. As I've mentioned to you already, local land charges searches are not 100% reliable. The pandemic problems created a vast amount of delays relating to local land charges searches. Some local land charges departments are still not working to their expected efficiency, so there are still delays. Personal searches are possible. I've mentioned the fact that Con 29 and Con 29 optional potentially have a weak spot in that the radar that Con 29 and Con 29 optional generates isn't a radar that would reveal development relating to private roads that could impact on your client's enjoyment, use, amenity, and/or value of target property. What I'm saying to the profession is that we've got a client who's buying a property in a rural area, buying a property where there is potential development within the vicinity or redevelopment in the vicinity, then explain to the client the benefits of a Con 29 option, which would reveal perhaps information that a Con 29 wouldn't. I mentioned in the notes SIM searches. And SIM searches, of course, are going to be undertaken where land is unregistered, but I also think they should be undertaken where you're acquiring complex registered titles. Dealing with something at the moment where a client is buying a rather nice house that is comprised of 3 registered titles. There are some lenders that will not lend where a property is composed of more than 1 title, so be aware of that. But also be aware that where you're acquiring 3 registered titles, although it would appear obvious that the 3 titles are but one another, it may in fact, in reality, not be the case. So I have seen on occasions too numerous to specify situations where there've been tiny slivers of unregistered land sitting between registered parcels of land. And again, that can cause problems or issues with regard to site assembly projects, development projects, etc. Can also cause significant issues with regard to lenders' security. I mentioned cautions against first registration being revealed, and again, I've dealt with 1 or 2 negligence claims over the last few years where lawyers have advised clients about the need to lodge a caution against first registration at the land registry, but then not explain to the client what a caution against first registration does. A caution against first registration does not protect an interest in unregistered land. It simply acts as an early warning system with regard to claims relating to the interest in land during the first registration process. Environmental searches, again, it was interesting seeing my friend from Landmark. Again, Landmark are a great provider of environmental searches, highlighting issues associated with contamination risk, amongst other things. It's important that clients understand that contaminated land is not simply an issue for brownfield sites. I live in a rural area, probably as rural as you can get, but in 1828, where I live was probably an industrial estate by the look of it. There were 49 mine shafts within a mile radius of target property, my property. There is about 100 meters to the east of me what was an old wooden wagon way where they used to take coal from the nearby coal mine down to the river. There is at the bottom of the garden a site that was used for making charcoal in the past. Charcoal and the production of charcoal generates all sorts of nasty chemicals which have leached into the ground. At the bottom of our garden is a river, and there was at some stage some staithes where boats used to come alongside and take coal down to the sea. And again, there's quite underground, there's quite some extensive reserves of coal sort of sitting there that everyone's forgotten about. So, what appears to be a rural property without any form of industrial activity anywhere near it, in fact, is a pretty contaminated site. We had an environmental search and report undertaken when we bought the property, and it was at first blush very frightening to look at it and think, crikey, what on earth are we buying? The reality is that there is risk, there is contamination, we're aware of it, and all you do is deal with land management so that you're not disturbing anything or causing any problems. So, for example, where the charcoal burning took place, we certainly wouldn't be growing vegetables or indeed anything else for human consumption. I mentioned leasehold transactions. Be careful. If you're acting in a residential leasehold transaction, your leaseholder buyer client could be liable for decontamination directly as a current occupant of the land in question. But more likely, the landlord would be liable for decontamination issues, but would more than likely be able to transmit cost into service charge in most residential leases. Moving on, other searches, mining searches, chancel repair, liability, etc., where you're getting search results in, explain to the client what the search result is and advise the client as to what steps can be taken in order to limit or to identify risk. Pushing along, I want to talk now about dealing with TA forms. And here, let's just go back to basics for a moment and think about how we protect our seller client. The idea of TA forms is that the client completes the forms in isolation without any legal advice. The forms make that clear. The forms also contain a number of warnings to the buyer, to the seller client about how they should approach completing the forms. I think your task is to tell the client and reinforce to the client the need to answer the forms as honestly as possible, and to make sure that the client is aware that if they are deceitful, if they are negligent, or if they're plainly just wrong, but that error is innocent, they could potentially be liable for misrepresentation. And that liability for misrepresentation could mean that they are required to pay damages to the buyer, or alternatively, in worst case scenario, be obliged to enable the buyer to rescind the contract and walk away from the transaction. So I think a seller client needs to be told to take the task of completing the TA forms seriously. The second thing is when the client is completing the TA10 form and there's any suggestion as between seller, buyer or agent that there are items that are fittings that are being purchased that would enable an apportionment for SDLT purposes, it is essential that that apportionment is fair and reasonable and justifiable, in order that any allegation that a fraud has been perpetrated against HMRC can be avoided. Because if there is such a fraud, the seller's solicitor that prepared the contract and the buyer's solicitor or conveyancer that submitted the HMRC return is potentially in the firing line for aiding and abetting such a fraud. I'm not saying for the life of me that with every client that you've got, you should warn the seller client about Section 2 of the Fraud Act 2006. If lovely Mr. and Mrs. Smith that you've acted for 30 years and have bought and sold numerous properties with you come to see you, I'm not for the life of me saying that you scare the living daylights out of them by saying to them, if what they say in the TA forms is defective, they could potentially commit a criminal offence and be sent to prison due to Section 2 of the Fraud Act 2006. But if you've got a client that has a cavalier attitude towards completing the forms, or is not taking the questions that are posed in the form seriously, I would advise the client about Section 2 and its potential criminal consequences. Your job is to look at what the seller says in the TA forms, compare it to the information that you have on your file, and advise the client should any of the answers that the seller has provided require readdressing. It's also important when you're acting on behalf of a seller to tell the seller client about the fact that they are under an obligation to notify you, and you are under an obligation to notify the buyer's conveyancer as to any changes with regard to the information that is contained within the TA forms. If you're acting for a buyer, I would always say that the client should be told that the questions in the TA forms are a checklist, and that your client should satisfy themselves as to the questions that are being posed. I think it's important that a buyer client knows that there is the potential to bring a claim for misrepresentation against the seller, but I would also be realistic and say to the client that's likely to be an expensive exercise, likely to be a time-consuming exercise, and an exercise to which you can't give any guarantee of success. Next thing to talk about is inspection and survey. And the first thing to do is to mention, as far as lender requirements are concerned, the lender's handbook does require the buyer client to inspect target property. And the lender's handbook also suggests what clients should be advised about in connection with survey and valuation, and in particular, the limitations of relying on a lender's valuation rather than the client engaging their own surveyor to produce a level 3 survey. Clients should also be told about the need to inspect, and that inspection should be an inspection before exchange, at exchange, before completion, and at completion. I've already mentioned to you about the RICS Consumer Guide relating to surveys. I repeat my advice that that guide should be provided to the client, and the client should have drummed into them the need to obtain the best survey they can possibly afford. Moving on from that, if possible, I would also like to suggest to clients the need to inspect before exchange of contract. And as far as that inspection is concerned, it is for 4 reasons. Firstly, to identify state and condition of the property, the sort of caveat emptor principle. Secondly, to identify the physical extent of that which is being acquired. Thirdly, to check the information in the TA forms is consistent with what the client sees. And fourthly, to identify overriding interests. Now, I know that you're dying for me to continue, but it's 1 o'clock. So what we'll do is have a little 5-minute break, and then we'll resume. Then we'll see if there's any exciting questions. And then if there isn't, I'll share with you some detail about the 4 reasons that our client should be told to inspect, and a little bit of practical advice that I think can assist you and your client to protect yourselves with regard to that inspection exercise. So I'm going to turn my microphone off for a little bit. We'll have a little break for 5 minutes, and then we'll resume if that's okay. Lovely. Thank you very much. Thank you.
Thank you.
Okay. Time flies, isn't it? Any questions, any issues, any problems? Just have a look at the chat box before we start again. If I can find it. There we go. So I don't think there are any questions. What am I being asked about at the moment? Estate rent charges. Lots of people are asking me questions about. I'll come on to that question, Adebayo. Thank you for that. It's Johnny, isn't it? I'll come back to that question. Estate rent charges, be careful, because if a client fails to pay an estate rent charge, the enforcement action that a rent charge owner can impose are very draconian. So either you want provision in the transfer that compels the developer to give notice with regard to demands for payment, and then reminders before taking any form of enforcement action, and exclude the operation of the enforcement action available under Section 121 of the Law Property Act 1925, or you potentially got a problem in your hands. Where a developer or builder won't allow that, then what I would do is warn the client about the very draconian enforcement action that can be taken where rent charge, where an estate rent charge isn't paid. So go to this question. I think it's Ajani. Do executives have to complete protocol forms? The answer to that question is the protocol requires the seller to complete the forms. Frequently, it will be inappropriate for an executive to complete it because they won't have any knowledge. So it depends. If an executive has knowledge, they should complete the forms. If they don't, then I think it's acceptable to say they're not aware of any of the answers to any of the questions that are posed. Hopefully that answers the question. That's great. Okay, thank you. And is it Adebayo or is it Anjanio? I'm not quite sure surname or forename. Adebayo, sorry about that. All right, thank you, but great question. Yeah, lovely. Thank you. Sorry about that. Great. Any other questions? The other thing I'm often asked about these days are determined boundary applications. Be careful. Well, in fact, any land registry application that you make, if it's opposed, the land registry will give the parties about 3 months to try and achieve a negotiated settlement. If they don't, they'll refer the matter to first tier tribunal. And if you are bounced into a first-tier tribunal application as a result of an application to the land registry or an objection to an application to the land registry, you can't unilaterally withdraw, and the very serious consequences. In the good old days or bad old days, the matter would be referred to adjudication, and unless your client behaved unreasonably, there'd be no vulnerability as to costs. These days there is, and I was talking to someone just recently who objected to a land registry application unsuccessfully, and their client was liable for £30,000 worth of costs. Ouch, was the cry. So we were talking about inspection, weren't we, and client inspection, and I said we'd talk a little more about the before exchange client inspection. Clients should be looking to identify the information that's been provided in the TA forms to make sure what the seller is saying in the TA forms is correct. They should also be identifying the physical extent of the property that they're acquiring. To that end, I would provide the client with a copy of the agent's particulars, copy of any mortgage valuation or survey, explain to the client how the property is described in the contract and on the title in the property register, and ask the client to confirm is what they see consistent with what we've provided to them, and are all the documents that we've provided consistent with each other. Note, I haven't thus far referred to a land registry title plan. Again, I was speaking at a conference yesterday and I was amazed how many people will send a buyer client a copy of a title plan without a health warning. The health warning that needs to be sent is that the client needs to be told that a title plan cannot be relied upon and provides a general boundary, not a legal boundary, courtesy of Section 60 of the Land Registration Act 2002. Additional inspection is necessary, in my view, at exchange if the property is empty or prone to vandalism, before completion if we don't trust the seller, and at completion to identify disclosable interests. Remember that your client is deemed to have knowledge of anything that is revealed during an actual inspection and anything that would have been revealed by a reasonable inspection. And one of the things in connection with a pre-exchange inspection that we've got to be careful with is to make sure our client understands what overriding interests are, and the fact that our client could be bound by an overriding interest even though it's not noted on the title. It's not sufficient, in my view, to tell clients, tell me about any overriding interest that you see, on the basis that the client is not going to have a clue what an overriding interest is. I therefore think it's incumbent on the buyer conveyancer to explain to the buyer client what overriding interests are and what should be drawn to the conveyancer's attention. I think it's also important to make sure clients are aware that they are bound by what a reasonable inspection would reveal, which then begs the question, what is a reasonable inspection? Opening the doors to all cupboards, inspecting all rooms, attics, cellars, gardens, grounds and buildings within them, and putting anyone who's in occupation on the property on inquiry if they're not the seller or party to the contract. Surveys and valuations we've talked about, so we can skip that one. And the next thing I want to talk about is interpreting electronic searches. And when we talk about interpreting electronic searches, really what I think we mean is to look at how we deal with electronic search results. And in essence, what we should do, just as I was mentioning with sort of usual searches and normal paper-based searches that are provided to us, it's important for us to scour the search to identify any issues that are adverse or that impact on client objective, use, enjoyment, amenity, or value of target property. And then to explain to the client what steps can be taken by the client, or indeed us, if instructed, to identify, limit, or expose risk. We are going to utilize these search results into our report on title. And it's amazing at the moment how frequently I'm being asked by numbers of different organizations about my views of the use of an electronic report on title or a standard report on title framework where data is migrated from search results automatically into the report on title. So I'm asked, what do I think about it? And my view is this. A lot of professional indemnity insurers are telling me at the moment that claims against conveyancers, although high, are shifting in nature. that in the past, what you'd have are negligence claims resulting for some form of procedural failure. And what insurers are saying to me now is that we're not seeing as many procedural errors, but what we are seeing are errors with regard to soft skills, failure to communicate or communicate effectively what we're finding to our clients in the report on title. Therefore, I think the idea of an electronic or a framework report on title to use as a firm is a good thing. It means that we can use it as part of our case management systems to make sure we don't miss things and to make sure that we're able to populate a report on title that contains all the necessary information that our client requires. So to that end, I think they're great things. The opposite position, however, is that it flies against the point I made earlier about there isn't such a thing as a standard client. And therefore, I think it's necessary that a report on title is personalised, particularly with regard to client objective. And the other thing that worries me a little is that in producing a standard electronic report on title where data is migrated into it automatically, the danger with regard to that is we're producing reports on title that are too bulky, too extensive, and that we're shooting ourselves in the foot in that there isn't really an expectation of the client to read or to be able to read such a bulky and wordy document. So all I would say to you is just bear in mind the fact that if you are using some form of platform that enables you to produce a report on title, migrating data automatically from your data sources, great idea. It enables us to spend more time thinking about how do we personalize the report, how do we extract from our due diligence process information that is going to be meaningfully transmitted to our client. It also should give us more time to take our client through the report, either on a face-to-face basis or virtually, highlighting to the client particular issues and emphasizing particular matters, or extracting from the client whether the client wants additional research or work to be undertaken with regard to risk that's identified. Which leads me to talk for a little while about reports on title. I've given you details relating to this in the notes. I'm just looking for the relevant page. Here we are, page 14 of the notes. Before I start, I have given you at page 14 and 13 some case law to explain what a conveyancer is required to advise upon. Generally speaking, a conveyancer is not expected to advise upon the commerciality of the transaction. You know, is this a good, bad, or indifferent deal? It's not for us. The client is old enough, wise enough, hopefully, to be able to make their own choice. Interestingly, the SRA has said that sometimes deals can be so bad, transactions weighed so heavily against the client that a reasonable conveyancer would come off the fence and say to the client, you know, you really shouldn't be doing this. The sorts of circumstance where that would be appropriate might be where we've got inexperienced clients who are first-time buyers, situations where clients should have had a property valued or surveyed and haven't, or situations where our clients are desperate and deals are being done in desperation. The sort of situation I'm thinking there is a situation where our client is in financial difficulties and is going to one of these companies that will acquire the freehold at a significant, or leasehold interest at a significant discount, and then offer a tenancy for life. Is that an appropriate and satisfactory way of dealing with what is a major issue for the client? Is there not alternatives, or are there not alternatives that our client would be better served exploring? So assuming that we've covered all those and assuming that we are producing a report on title in a residential transaction, what should we do? Well, I think the first thing that we should do is set realistic client expectation, to explain to the clients quite clearly the limitations of the due diligence process. And I've made the obvious ones already, the obvious points already. One, the fact we're not going to be inspecting the target property ourselves. Two, that we rely on our client to report to us anything they see during inspection. Or three, that we're reliant upon what the surveyor or valuer has to say. It might also be important with regard to a report on title to explain to the client that with regard to environmental searches and reports, surveys and valuations, that we are not qualified or in a position to give our client advice relating to the content of the reports, save for information relating to title issues that the surveyor or valuer identifies in the survey or valuation. I think the next thing we should do, and again, we've covered this off already, is to explain to clients the limitations relating to searches, and that the searches that we undertake may be defective, but if they are, then it's possible to seek recovery of loss via the appropriate indemnity schemes. I think it's important with regard to a report on title that if we haven't already, we explain to the client the conveyancing process and the significance of the exchange of contract stage and completion. And again, the importance of the client being aware that completion isn't simply the end of the matter and the closing of the file, but the need to deal with SDLT and also the need to deal with land registration with regard to registration of disposition. All of these things require careful consideration and again should be included or repeated in the report on title where they've already been mentioned. I think matters which are outside the remit of the report should be spelt out to the client. The commerciality of the transaction, issues such as planning issues, issues such as valuation issues, issues related to state and condition of the property, and again highlighting that we haven't inspected ourselves. The report should cover the following. 1, an outline of the conveyancing process, if not already provided. 2, the terms of the contract, price, timing, and whether the contract contains any conditions. What the official copies of the entries of the register reveal, but that wouldn't mean simply referring to them and annexing them to the end of the report. There should be an explanation as to what they mean. So, for example, if we're looking at a charges register and there are notices in the charges register, I'd explain to the client that those charges relate to mortgages, which will be discharged at completion. That the notices may also refer to restrictive covenants, which have the potential to be enforceable and will remain enforceable and binding on the buyer after completion. Interesting point here with regard to notices. A notice does not validate or legitimize an interest in land. A notice is placed on the land register simply because the land registry has received an application and that the land registry is satisfied that the appropriate procedure is being complied with, and there is evidence that there is potentially a valid interest in land that is capable of being protected. A notice does not validate or legitimize an interest in land. Important point. The next thing that I think is important, that the report on title should highlight the extent of the land that is being acquired. And again, I would refer to client inspection, title plan with a health warning, other plans and other descriptions that enable me to identify the extent of the land. I think it's also important that the report on title highlights where there is land in the vicinity that has the benefit of the covenant, or land in the vicinity that has benefit of easements over the land that is being acquired, easements reserved, that land is highlighted or identified. It's important that all rights benefiting the property or that burden the property are identified and described, and where necessary, that a connection is brought between the description of the right and its impact on client objective. As I mentioned in the notes, I think extreme care needs to be taken with regard to prescriptive rights. Because remember, as far as prescriptive rights are concerned, these may well be legal rights. In particular, I'm thinking of easements, in which case they may be noted on the registered title, but they may not be. They may be overriding interests, which again is why it's so important that when our client is buying a property, they inspect the property, but are made aware of what overriding interests are, made aware of the fact that they should be reporting to you their existence. And in the report on title, you should be reporting back to the client the consequence of what you've been told or what you've identified. I mentioned that when we look at the property register, we should consider any reservations and exclusions that apply, mines and minerals in particular being the obvious one. I think it's also important that if there are restrictions on the title, we identify how those restrictions will impact on the client's purchase of the property and use and enjoyment thereafter. With regard to restrictive covenants, it is important, I think, to advise the client that just because a restrictive covenant is noted on a title does not mean the covenant is binding. I would also explain to the client that where a covenant will impact on client objective or value of the property, I'd identify whether you consider the restrictive covenant is in fact enforceable, looking at the sort of Tulk and Moxhay test to identify that the restrictive covenant is negative in nature and scope, identify that there is land in the vicinity that benefits from the covenant and someone owns that land that could enforce it. I would also explain to the client the availability of Section 84 of the Law Property Act 1925 to vary or remove the covenant on application to Land Tribunal. Where there's a restrictive covenant, I'm not sure whether it's enforceable or not. In my report on title, I would be advising the client of the benefit of defective title insurance to avoid protection to the client in circumstances where the owner of the land with the benefit of the covenant comes out of the woodwork. As far as restrictive covenants are concerned, I think where they are going to impinge on value or impinge on client's objective, we need to be careful to assess their enforceability. Where there are restrictive covenants that are not going to impact on valuation or client objective, I would simply report to the client their existence and advise the client that I haven't investigated to determine whether the covenant is in fact enforceable or not. So if I'm buying a property and I've told you I'm buying it as a family home, the fact there's a restrictive covenant that precludes the manufacture or sale of alcohol is not going to impinge or affect my amenity relating to the property, nor is it going to affect value. So in those circumstances, I wouldn't expect my conveyancer to spend many an hour determining whether the covenant is in fact enforceable, and if so, by whom. I mentioned that we should look at the class of title that is being offered by the seller and to explain to the client the significance of that title. I should explain to the client where I'm taking out a defective title insurance policy, what the defect in title is, the fact that that defect in title remains, and that all I'm doing in essence is providing or buying a shield or a sword for the client that will enable the client to defend or bring proceedings and potentially will assist the client with regard to loss if the client sustains any. As far as other rights are concerned, I've given you details in the notes. Unregistered land, there would be a requirement for a thorough and detailed analysis of all the documentation, including the root document, chains of ownership, and ensuring that documents are being properly executed, properly stamped, and that there aren't any memorandum annexed to documents that reveal sales of part or whatever. The report on title does need to refer to documentation, and it's perfectly acceptable to annex the documentation to the report. But again, I'd be concerned about the extent of the report and just how much information you are providing. Important not to overburden the client. Might be prudent to provide the client with a series of interim reports on title, then provide the client with a final report for the client to consider. I mentioned in the notes at page 16 the need to make sure that a report on title is accessible. In other words, that the client can understand it and read it. Now, I concede that there will be clients that you could spend from now till Christmas this year attempting to explain some of the intricacies of what you found in your report on title and in your due diligence exercise, and the client wouldn't understand it. What I would say to you is that it is your responsibility to protect yourself and your firm to have evidence on the file that you've done your level best to ensure the client does understand it. To that end, I would want a client of mine to sign or acknowledge receipt of the report on title, to confirm that they'd read it, to confirm that they understood it, and to invite the client to raise any questions that are arising from their reading the report. The reason that I would do this is that I don't want the client at some stage in the future to say, yes, I got an 80-page email from the solicitors acting for me on the purchase, but I didn't read it, or I did read it and I didn't understand it. Or I had a meeting with my conveyancer and he or she went through the report on title, but again, that interview or that meeting lasted 3 hours and I didn't grasp each and every point. So again, it's a question of just being careful, being practical. Would I ask a client to sign a report on title? Yes. Would I ask a client to sign an attendance note as a true record of what was discussed at that meeting? Yes. Exactly the same principle would apply to a telephone conversation, where what I'm suggesting to the client, I think, is not being received properly, or where the client is happy to proceed with regard to a transaction or a step or a procedure that's contrary to my advice or recommendation. I mention in the notes that as far as dealing with searches are concerned, the points that I mentioned to you earlier about making sure the clients understand the limitations of searches, I think is important and requires addressing. The next thing I want to talk about are land registry restrictions. So let's just drift on to something slightly different at this point in time. And let's start with the fact that a land registry restriction is a method of controlling or managing the registration of a disposition. The use of a restriction must be necessary and desirable to protect a relevant right or claim, courtesy of a case of J. Singh against Liange. And in addition to that, as far as a restriction is concerned, a restriction must not blight a title. In other words, a restriction that is placed on a registered title must be capable of being complied with. It is important that as far as the restriction is concerned, it is placed on the title by a restrictioner, and the application to place the restriction on the title was done with reasonable cause. In other words, it must have been reasonable for a restriction to be placed on the title in the first place. So remember, as far as restrictions are concerned, they can protect beneficial interests under a trust. There are certain other rights and interests in land that can be protected by restrictions. Generally speaking, your first port of call to protect an interest in land is to look at whether or not it can be protected by restriction. Only where you determine it can't would you then go on to consider whether the interest in land could be protected by notice. And of course, if an interest in land is an overriding interest, then it isn't necessary to utilize a restriction or indeed a notice to afford protection for it. With regard to the wording of restrictions, important to understand the Land Registry has created a series of standard form of restriction, and the Land Registry will encourage the use of a standard form wherever possible. Remember, the Land Registration Amendment Rules 2008 changed a lot of the wording of restrictions so that solicitors and conveyancers acting on behalf of a buyer are able to give consents, certificates, permissions, etc., as required by the restriction. Be aware that Land Registry Practice Guide 19 has been altered so that there is an addendum to Practice Guide 19 that highlights some of the issues associated with restrictions in connection with residential leases. I've given you detail with regard to that in the notes. Be aware that we can utilize a double L restriction to prevent property fraud. This is a restriction that's placed on our client's own title and requires you as a conveyancer that place the restriction on the title to confirm and verify the client's ID. Double L restrictions have come in for quite a bit of criticism. One, because they impose an obligation on the seller's conveyancer to verify ID. Secondly, because there's been some confusion as to who verifies identity. Is it the lawyer or conveyancer that put the restriction on the title in the first place? Or can the double L restriction be complied with by the current conveyancer? To be honest with you, I get varying views from different land registry officers with regard to the answer to that question. A restriction has to be capable of being complied with. If it can't, then it is possible to disapply, cancel, or modify the restriction. Yesterday, I was talking at a conference about overage and protecting of overage. And I put to the room what was the best method of protecting overage. And the vast majority of the room suggested that the use of a restriction. And I explained to the room that a restriction to protect overage is dangerous because a restriction can be disapplied, cancelled, or modified, courtesy of Section 41(2) of the Land Registration Act 2002. Disapplication means the restriction does not apply in connection with the current disposition. Disapplication is a relatively simple process that would require you to satisfy the land registry that the restriction can't be complied with. As far as that application is concerned, it is important to appreciate it is a temporary measure, that the appropriate form that you use is an RX2, and the land registry will put a notice of disapplication on the title. But the disapplication only applies for current disposition and reappears in connection with later dispositions of registered land. Cancellation and modification is permanent, but the land registry will normally want to undertake their own investigations to see why the restriction can't be complied with before a permanent cancellation or modification is permitted. If you are acting for someone that places a restriction on the title, I think it is important that the applicant is aware of the fact that the placing the restriction on the title imposes a duty on them to react quickly and sensibly where steps are being taken for a request or certificate or consent to comply with the restriction. And I think the other important thing to mention relating to restrictions is that the restriction has to protect an interest in land. And you should always bear in mind that the client who has placed the restriction on the title is aware of the fact that if they receive a communication from anyone about the restriction, they should react swiftly to avoid a disapplication, cancellation, or modification application being made. In the notes at 21, I deal with a lot of detail with regard to restrictions and leases. The land registry are telling me on a fairly frequent basis that they're encountering situations where management companies that no longer exist or landlords that no longer exist have the benefit of restrictions, and in those circumstances, disapplication, cancellation, or modification ought to be made to enable the disposition of the registered land to proceed, the assignment of the registered lease to proceed without need to comply. Someone was asking me yesterday, what's the position if a landlord is asking for an extortionate amount of money in order to provide a consent or certificate? Could you apply to disapply or cancel or modify the restriction in those circumstances? The answer to that question, unfortunately, is no. But what you can do is you could apply to first-tier tribunal, the first-tier tribunal to determine that the fee that the landlord is claiming is unreasonable. A fee for a consent or certificate in this context would be an administration charge. First-tier tribunal has jurisdiction to determine what the fee should be and what a reasonable fee is. And if what the landlord is charging is not reasonable, then it will be possible to make application to cancel, disapply, or modify the restriction. You can tell that the land registry is frequently faced with problems with regard to restrictions relevant to the disposition or assignment of registered leases because of the amount of information that they provide in connection with Practice Guide 19 in that regard. I want to talk now for a little bit about adverse possession. And again, I'm being asked a lot of questions about adverse possession at the moment, either by owners of paper title who are losing land due to adverse possession, or adverse possessors that are being successful or unsuccessful with regard to an adverse possession claim. The most recent of the requests for information came yesterday, where someone was telling me that their client had built a brick wall around a piece of land. They did that over 20 years ago. The only way that the land within the wall could be accessed is via the applicant's garden. The applicant had submitted an application for adverse possession and the land registry had rejected it. On the only basis of rejection that I could see is the land registry were not happy with the statement of truth from the applicant. My view was that if there was additional information to confirm from a third party that this is what the applicant had done, I couldn't see why an application for adverse possession would not be successful in that context. With regard to adverse possession, I state we require factual possession of the land. And as far as factual possession of the land is concerned, it is important to understand that that doesn't mean ownership. It doesn't mean complete and total possession. It means something significantly less than that. If the land is registered, the period of adverse possession is a period of 10 years. If the land is unregistered, the period of possession is a period of 12 years. It is important to understand, as we'll see in a moment or two, that adverse possession applications require the applicant to consider who is the owner of the paper title, because there are some owners of paper title that would automatically disqualify an adverse possession claim. So I pose on question here, what do we mean by factual possession? And to answer that question, if we look at the bottom of page 24 of the notes, I refer to Powell and McFarlane and J.A. Pye, Oxford against Graham. Two quite old cases now, but in essence they mean an appropriate degree of physical control, single and exclusive possession. It isn't necessary for it to be fenced off or walled off or indeed anything else. It simply means a degree of physical control which could be tending to grass or tending to plants or vegetables. It is important to understand that the owner of the paper title must not have consented or granted some form of right, informal or legal, relating to occupation. And it is important to understand that when we talk about factual possession, the factual possession and legal possession can be lost if the occupation of the land is not unequivocal. So if I am granted a license over land, then I can't bring a claim for adverse possession relating to it. If I have a right of way over land, the same principle would apply as it would if I were a tenant over that land. But factual possession is not perhaps as high a bar as some people think, on the basis that it doesn't have to be fenced off, nor does it have to be differentiated from other land, other than with this idea about physical control on the, in favor of the applicant. There has to be an intention to possess. And as far as that is concerned, whilst enclosure is strong evidence of an intention to possess, it is not conclusive or exclusive. It may be possible to establish an intention to possess on the basis of what the applicant thought or did relating to the land. And there must be possession without the owner's consent. I mentioned to you already the fact that as far as possession is concerned, the moment that we've got some form of lawful use over the land, we can't have an adverse possession claim. I've referred you at 27 to Buckinghamshire County Council against Moran, which is authority for that proposition. And I also mentioned that there are restrictions relating to adverse possession. And the first one is that the paper title owner may mean that the adverse possessor is disqualified from making an application. So where the registered proprietor is an enemy or detained in enemy territory, then you're not going to be able to make a claim. Where someone that is registered proprietor is suffering from mental incapacity, so they can't make decisions relating to their land ownership, again, you'd be excluded from making the application. Where the applicant is a defendant in proceedings relating to trespass, involving asserting a right of possession of the land or judgment for possession has been given in the last 2 years, you'd be precluded from making an application. And where an estate in land is held on trust at any time during the period of 10 years on the date of application, again, you wouldn't be able to make an application unless the interest of each beneficiary in the estate was an interest in possession. So that means that the sort of trust where a co-ownership exists would not preclude an adverse possession claim, but a sort of traditional beneficial under a family trust might preclude a claim. Not a lot of applicants and their lawyers are aware of these restrictions relating to the paper title owner. So it's always worth investigating who owns the paper title before making an adverse possession claim. Remember that with regard to a claim, the important thing to note if you're acting for a paper title owner is the need to object to the application by serving counter notice. And in those circumstances, once that counter notice is served, then the application for adverse possession must fail unless the applicant can bring themselves within one of the 3 exceptions. The exception that I'd like to major on for a few minutes now is the exception relating to neighbor encroachment. In neighbor encroachment, remember, it is possible to bring a claim for adverse possession, but it is necessary for the applicant to have a reasonable belief that the land belonged to them. In the notes, I've mentioned this is at page, just bear with me while I find the page. Page 28, 29. Zarban Parry, Thorpe against Frank. These cases sort of highlight the fact that it isn't necessary to have reasonable belief at the point of application. Because why would you claim adverse possession if you had a reasonable belief that the land belonged to you? So the point is that during the 10 years of your adverse possession, you had a reasonable belief that the land belonged to you. And that could arise because on acquisition of the land, you were told by your conveyancer that the land belonged to you, or that there were other inquiries that were made that led you to the same reasonable conclusion. This sort of claim arises where a sort of neighbour is claiming adverse possession due to boundary encroachment against another neighbour. And again, the case has sort of explored recently the issue about what is the position relating to a reasonable belief. Do you have to have it for the duration of the 10 years? Do you have to have it immediately before you submit your application for adverse possession? The idea of having a reasonable belief that the land belongs to you, but then claiming adverse possession relating to it doesn't sit comfortably, but the courts have now clarified that position. Just quickly, two other things I want to mention before I finish today. Firstly, the issue of insurance. Always check the contract, see what the position is. Of course, a buyer is normally obliged to insure beyond exchange, but sometimes the seller may insure because of mortgage obligation, lender obligation, or obligation with regard to a residential lease, for example. If the position is that the seller is to continue to insure beyond exchange, we need to ensure that the appropriate standard condition is removed from the contract. What's your role with regard to insurance? If the buyer is obliged to insure, to make sure the buyer is aware of it, do you need to see the policy? I think it's good practice to protect yourself and indeed your client to ensure that you do. Having said that, you're not obliged to give advice generally with regard to buildings insurance. On the issue of defective title insurance, be aware of the fact that you are entitled, courtesy of your professional qualification, to take out a defective title insurance policy, but you must advise your client when you're taking out a policy that you're not authorized to trawl the market to determine which is the best policy, which is the most cost-effective premium or cheapest premium. All you're doing is finding one product that meets the client's needs with regard to the defect in title. Again, I've been asked that question recently, do we have to trawl the marketplace to find the best policy? Answer, no, but you've got to tell your client about the limited extent of the work that you're doing with regard to a defective title insurance policy. And remember, as I mentioned to you earlier, a defective title insurance policy does not remove or eliminate the defect. It simply provides your client with a shield or a sword. Important, in my view, to protect yourself and your client upon the conclusion of your instructions, where a defective title insurance policy is being taken out, to advise the client that a policy has been taken out and to remind the client about their duties and obligations under that policy. Those duties and obligations should have been explained by you to the client when the policy was taken out. I would also advise the client upon conclusion of my instructions. I would advise the client of two other things. They need to keep their address for service at the land registry up to date, and where my client has purchased the property as a co-owner and as a tenant in common, if a deed of trust has been created, of the need to keep that deed of trust under review. The next thing I mention at page 31 are issues with regard to the duty to explain and about knowing our client. And the first thing I want to talk about is this issue about the duty to explain. How do we deal with documents? What happens if we see documents that contain vague or ambiguous provision? We're under an obligation to explain to the client that there is vague or ambiguous provision within the document, and that our view is that this vague or ambiguous provision should be interpreted in a particular way, if we're able to do it. But then we should then explain to the client that there may be an alternative view, and the only real way of testing who's correct with regard to their interpretation is for the matter to be litigated. We've already discussed the need to explain searches rather than simply provide clients with the information that the search reveals. And we've also explained at some length the circumstances where it's necessary to give advice. As far as the duty to explain is concerned, we must explain to our client such that the client understands. and such that we have evidence to confirm that understanding. The whole idea of communicating with a client is a two-way process. We can't simply bombard our clients with information and assume that our client understands. We've got to take steps to provide our client with an opportunity to give us evidence that they do understand. I have seen that being taken to some quite extraordinary degree, or to extraordinary extent. For example, providing the client with a quiz or a questionnaire to complete when they've read a report on title. Don't think it's quite necessary to go that far, but I have seen on the Leasehold Advisory Service website, for example, a questionnaire called "Do you know your lease?" And I do know some firms that when their clients are dealing with leasehold transactions, the firm asks the client to complete that questionnaire as proof that they've read the report on title and the lease that's been provided to them. I mentioned in the notes that as far as this issue is concerned about understanding our client, there are different clients with different needs and different levels of knowledge and experience. And therefore, we have to target information that we provide to our clients in the knowledge of their type and in the knowledge of their experience and understanding. So we'll act for clients that are knowledgeable and experienced. We've acted for them on many occasions before. We've bought 5 or 6 houses for our clients. The only thing I would say there is be careful. Your client may be very experienced in connection with standard freehold purchases, but may be currently downsizing and have never bought a leasehold flat before, in which case the client is in essence a first-time buyer. The second thing we've got to be aware of is risk-averse clients, and the fact that it may be possible to provide such a client with some comfort. So we might explain to all our clients about the risk of seller identity fraud. We might have some clients that are absolutely terrified at the prospect of buying a property, paying over huge sums of money, and then finding out that the person to whom the purchase price has been paid over is in fact a fraudster. What could we do with such a client? Well, we could advise the client that it is possible to take out an indemnity policy that could potentially protect our client in the event of total loss in circumstances where a fraudster manages to evade everyone's investigations and is a fraudster and is able to disappear off into the sunset with the proceeds of sale. Got to be careful with first-time buyers, of course. We've also got to be careful with elderly clients, particularly elderly clients that we're dealing with virtually or at a distance. Are we satisfied that the client has the appropriate capacity to instruct us? Are we concerned about undue influence where an elderly client is brought to us either virtually or in reality by a son or daughter? Again, a number of situations where that has occurred and son or daughter has basically taken the lead with regard to instructions. And it might be that there's undue influence or risk with regard to a conflict of interest in connection with such instructions. I'd always want to see an elderly client in isolation. I'd always want to test or challenge them to make sure that they understood what was being proposed and the risks or dangers, if there are any, with regard to what's being proposed. With regard to collective clients, it's important to understand that there isn't such a thing as a collective client. If you're acting for my partner and I, you're acting for us as individuals. We might have different attitudes to risk, different levels of understanding with regard to the transaction. It's important that you're aware of that and that you give advice, you provide information and documentation and explanation accordingly. Other points that I think are important about this idea about knowing your client. Making sure that you have evidence on your file all the way through the transaction that the clients have informed consent or can provide informed consent. How can I give you authority to effect an exchange of contract if I don't understand the significance of that exchange? How can I suggest that I'm happy to proceed on the basis of a defective title insurance policy if I don't know what the limitations relating to that insurance policy are? That's the sort of point that I'm making. There are some key questions with regard to this thing about protecting your firm and protecting clients. Determining just who you're acting for, being aware of who you're acting for, understanding and appreciating client objective, be it on a sale or a purchase. To understand what our role is, we're transactional property lawyers, we're not experts. Our task is simply to highlight to clients where appropriate expert advice or clarification is necessary. We need to understand what the transaction involves, and we need to make sure that our clients also understand and appreciate what the transaction involves and what their obligations and duties are. And as I've mentioned too in the past, this point about making sure the clients understand the limitations relating to the conveyancing process. To that end, when we onboard a client, I think in our engagement letter, we should be explaining to the client the conveyancing process and the limitations relating to it. We should be repeating those limitations in our report on title. And when we're concluding our retainer, at the end of the instructions, we should be explaining to clients about their ongoing duties and obligations to make sure that they're aware of their duties and obligations, notwithstanding that our file is closed. So if the client is buying land with the benefit of a restrictive covenant, the client should be made aware of the fact that they could lose the potential benefit of that covenant by failing to take action if they become aware that the covenant is being breached. Clients being made aware of the fact that where they are buying a property as a joint tenant in law and in equity, the fact that it's possible for either party to unilaterally sever the joint tenancy with all the issues associated with it. On the issue of co-ownership, again, 2 or 3 points really with regard to ensuring that we are explaining to clients and making sure clients understand what's happening. No such thing as sort of assumptions that are safe to make with regard to co-ownership. If our clients are proceeding on the basis of joint tenants, we need to explain severance and the fact that severance can take place unilaterally. Where our clients are buying as joint tenants, we need to ensure that our clients understand and appreciate what the doctrine of survivorship is, and of course the significance of common accident. In circumstances, the younger is deemed to have survived the elder. With regard to tenancies in common, we need to explain that the tenancy in common creates the need for a deed of trust, that the tenancy in common would require that we are careful to make sure our transfer recites the division of the beneficial interest. And of course, we need to make sure our clients are aware of what the transfer says. And of course, we need to make sure that our buyer clients sign the transfer as evidence of intent with regard to the beneficial interest. I've been doing some work with regard to the situations where a buyer client who's buying as a co-owner doesn't sign the TR1. And the interesting point here is that the case law is not conclusive. You should always ensure that where you're acting for buyers who are buying as joint tenants or tenants in common, they sign the transfer. Conclusions. I think with co-ownership, you always use a co-ownership questionnaire. You explain choice, you listen to clients, you give advice and assume nothing. It is just about 2 o'clock. So I'm going to finish and show you these points. It's important to explain to the client what due diligence involves, the limitations relating to due diligence. We need to be aware of client objective, and we need to make sure that we are reporting on title effectively. We are communicating effectively. I'm going to take questions now, but also draw to your attention the fact my email address is shown on slide, and you're more than welcome to fire any questions at me after the event if you wish. We've got a couple of minutes to deal with any questions, so I'm just going to have a look at the chat box and see if there are any questions. I think the only question that we've had today is from Adebeo, so thank you for that. Does anyone else have any questions? Well, on that happy note, you've either all gone to sleep or all left me. But in either way, thank you very much for joining us. What I'd like to do is leave you and thank once again Landmark for coming along today. Thank you for Helen for organising today's event. And thank you for Helen for inviting me.
Thank you, Ian. I've attended quite a few of your presentations in the past, and you've always provided really good examples of live cases that you've dealt with, which highlight the importance of understanding the client's objectives, fully understanding the whole transaction, any constraints there might be, and how to avoid any pitfalls. So thank you very much. It's always interesting. 2 hours has gone very quickly.
That's good.
So if there's no questions, I don't have any here at all. We shall end the session.
Thank you very much. Lovely to see you. Take care
Yes.
and stay safe.
You too.
Bye-bye.
Bye. Bye.